Hello and a very warm welcome to latest case analysis series by LawSikho. This is Monica Rahar, and for today's discussion, we have taken up another Allahabad High Court decision. The name of the case is Salamat, Ansari and three others versus the state of UP and three others. It is a division bench decision, and the bench consisted of Honorable Justice Pankaj Naqvi and Honorable Justice Vivek Agarwal. Now let's proceed and understand the issue of law. So the court was to decide whether right to choose a partner and live with a person of his or her own choice, irrespective of religion professed by them, is an intrinsic part of right to life and personal liberty, which is guaranteed under Article 21 of the Indian Constitution. Now let's proceed and understand the brief facts of the matter. So the cause of action arose because petitioner number 1 was Salamat Ansari. He performed nikah with petitioner number 4, who is Priyanka, now also known as Alia. So this nikah, it was performed against the approval of parents of petitioner number 4, who is the wife Priyanka. Now she belonged to Hindu religion before the marriage, and right before the marriage she converted to Islam. And they lived voluntarily and happily for a year. However, a year later, an FIR was lodged at the instance of father of Priyanka, and the FIR, it was lodged under the following sections of the Indian Penal Code, along with two sections of the POXO Act. So the first charge being Section 363, which provides for punishment for kidnapping, and the next charge being Section 366, which provides for kidnapping, abducting, or inducing a woman to compel her marriage, etc., and Section 352, which provides for punishment for assault or criminal force otherwise than on grave provocation, and Section 506 of the Indian Penal Code, which provides for Section 506 is punishment for criminal intimidation if threat be to cause death or grievous hurt, etc. While Section 7 of the POXO Act, it provides for sexual assault of a child, and Section 8 prescribes punishment for such an act of sexual assault. Now, when this FIR was lodged, the petitioners, the first petitioner being Salamat Ansari, petitioner number 4 being his wife Priyanka, petitioner number 2 being the mother of Salamat Ansari and mother-in-law of Priyanka, and petitioner number 3 being the brother of petitioner number 1 Salamat Ansari, they approached the Allahabad High Court and praying the invocation of extraordinary jurisdiction of the High Court, seeking quashing of the FIR and also a writ of mandamus against their possible arrest as a result of the FIR. Now let's proceed and understand the cases of both these parties, and let's first begin with the case of the petitioners. So the petitioners contended that the FIR was lodged with the sole purpose of bringing an end to their marriage, and their marriage was not lawfully contracted because the parties, they were competent adults to contract such a marriage. While the case of the respondent was that conversion per se for contracting a marriage, it is prohibited and such marriage has no legal sanctity. The court should not exercise its extraordinary jurisdiction in such a case, and the council cited two recent judgments of the Allahabad High Court itself. The first being the case of Shrimati Noor Jahan Begum, also known as Anjali Mishra and another, versus the state of UP and others, and the second case being the case of Priyanshi versus the state of UP and another, which is a recent judgment of the Allahabad High Court. Now let's proceed with the reasoning and decision of the court. So the court, if you look at the nature of the charges which were mentioned in the FIR, these are all dependent on the fact that the victim, the purported victim in fact, is a minor, which is Priyanka. So she was projected as a victim by her family in this particular FIR. So the court first made sure to look into the question as to whether she is in fact a minor or not. So the court came to the conclusion that she attained majority, and in order to substantiate that conclusion, the court looked at the high school certificate which was produced before it, and also the date of birth which was mentioned in such a high school certificate, which was not contested and challenged. Now, here we need to note one thing, that out of all the documents which are listed in the Juvenile Justice Act of 2015 for determining the age of a person who is seeking the benefit of being a juvenile or a minor, so the production of high school certificate is one such document. And then the court came to the charges of kidnapping and ascertained whether the charges of kidnapping are established or not. So the court came to the conclusion that the offences under section 363 and section 366 of the IPC, they're not proved, as she is not a minor, and the petition was accompanied by an affidavit of Priyanka herself showing that she voluntarily got married. And then the court came to the question of whether the charges or the offences under the POXO Act are established or not. So it stated that no, P4, which is petitioner number 4 Priyanka, she was found not to be a juvenile, and hence the offences under section 7 and 8 of the POXO Act, they are not established. And fourthly, with respect to whether the charges against mother and brother of petitioner number 1 Salamat Ansari, they were established or not, the court stated that no, keeping in mind the non-establishment of any other charges which are mentioned above, the charges under section 352 and section 506 of the IPC against the mother and brother of petitioner number 1, they were found to be exaggerated and also having malified motivation with a view to implicate the family of Salamat Ansari. Now, with respect to what all are the constitutionally protected rights of the couple, the petitioner number 1 and 4, the court stated the following. Petitioner number 1 and 4, they were not seen by the court as members of the Muslim or Hindu religious communities. Rather, they were seen as two consenting adults who were living together happily and voluntarily. The court, especially the constitutional courts, are empowered to uphold the life and liberty of an individual, which is protected under Article 21 of the Indian Constitution. Right to live with a person of his or her own choice, irrespective of religions which are professed by them. It is an intrinsic part of the right to life and personal liberty, and major adults that statutorily conferred with the right to choose a partner. So this is an answer to our question of law. The court further stated that when the law permits homosexual couples to live together, then neither an individual nor a family nor even the state can interfere in a relationship of two consenting adults who are living together, which is in fact the case in the present case. The court further stated that decision of an individual who is a major to live with an individual of his or her choice, it is strictly a right of an individual, and when this right it is infringed, it would constitute a breach of his or her fundamental right to life and personal liberty, as it includes right to freedom of choice, to choose a partner, and the right to live with dignity as enshrined in Article 21 of the Indian Constitution. The court then cited four leading precedents on this particular issue, and the first being the case of Shafin Jahan versus Ashokan KM. It is a 2018 decision of the Honorable Apex Court. In this particular judgment, it manifested that the Supreme Court has consistently respected the liberty of an individual who has attained the age of majority. The second case being the case of Shakti Vahini versus the Union of India. It is a 2018 decision of the Honorable Supreme Court. The Supreme Court in this particular case came heavily on the perpetrators of honor killings, which the court found not only horrific and barbaric, but also interfering with the right to choose a life partner and the dignity of an individual. So the Allahabad High Court stated with respect to this precedent that principles which were enunciated in this particular judgment, they would apply in the present context too, where relationship of two matured individuals is sought to be jeopardized at the whims and fancies of a parent. Now the third precedent being the case of Nand Kumar versus the state of Kerala. So in this particular case it was noted, or the Supreme Court in fact held, that on attaining majority, an individual is entitled to make his or her choice, which is pivotal and cannot be infringed with by anyone, be it an individual or a family member or even the state. And fourthly, the Allahabad High Court cited the leading case of the Honorable Supreme Court, which we also know as the case wherein right to privacy was termed as a fundamental right under the Article 21 of Indian Constitution. The name of the case is Case Puttaswamy versus Union of India. It is a 2017 case of the Apex Court. The Allahabad High Court reiterated certain paras of the judgment which were relevant, so I'd like to reiterate the same. So the Supreme Court held that privacy enables the individual to retain the autonomy of the body and mind. The autonomy of the individual, it is the ability to make decisions on vital matters of concern to life, the family, marriage, procreation, and sexual orientation. These all are integral to the dignity of the individual. Above all, the privacy of the individual recognizes an inviolable right to determine how freedom shall be exercised. Privacy of the body, it entitles an individual to the integrity of the physical aspects of personhood. The intersection between one's mental integrity and the privacy, it entitles the individual to freedom of thought, freedom of belief in what is right, and the freedom of self determination. When these guarantees intersect with gender, they create a rights, a private space, which protects all those elements which are crucial to gender identity. So, summing up this decision, the Honorable High Court of Allahabad came to the conclusion that right to choose a partner, irrespective of the caste, creed, or gender or the religion, it is inherent under right to life and personal liberty, which is an integral part of the fundamental right guaranteed under Article 21 of the Indian Constitution. Now, the court came to the second important aspect of this judgment, which is whether the cases of Noor Jahan and Priyanshi they laid down good law. So the court came to the conclusion that no, they did not. Now let's first discuss the case of Noor Jahan. In this particular case, the facts of the matter were as follows: that a conversion took place. The wife converted to Hindu religion from to Muslim religion. She was a Hindu and she converted to Muslim for the purpose of marriage. Now, the converted wife, she could not show the knowledge of basic tenets of Islam before the court, and she could not authenticate her conversion. Hence, the Allahabad High Court then held that marriage was illegal and it was performed after unlawful conversion. So, with respect to this judgment, the Allahabad High Court in the present case noted that once conversion is under clout, it is under doubt, and its validity is under doubt, then the Constitutional Court should ascertain the choice of the wife who is above the age of 18 years. And not doing so, it is antithetical to freedom of choice and it is also a threat to the concept of unity in diversity. Irrespective of the conversion being under clout, the mere fact that the couple was living together, alleged relationship can very well be classified as a relationship in the nature of marriage, which is distinct from a relationship arising out of a marriage in view of the Domestic Violence Act 2005. So, here we need to understand one thing, that when the entire concept of legality of live-in relationship it came to the forefront, so usually the cases which went before the court, they were either seeking maintenance or ascertaining the legitimacy of child born out of a live-in relationship, and mostly the aggrieved women used to approach the court. So the court, when it with the legality of the live-in relationships they were ascertained, then the court look at this phrase which is available in the Domestic Violence Act, which is a relationship in nature of marriage. So such a relationship, it is not a relationship which is arising out of a marriage, but it is a relationship which is in nature of marriage, wherein both the parties they are living together under the same roof, they are holding out to the public at large that they're living together as a couple, they're sharing their responsibilities, they are taking properties in their names, and they're living right exactly like a married couple lives. So such a relationship, it is a recognized relationship in our country. So live-ins, they're legal in our country provided these three four parameters they are met with. So the court here noted that if the conversion which the marriage is based. So if it is illegal, if it is not valid, or it is under doubt, then it is the duty of the constitutional courts to ascertain that the choice of the wife was there while contracting such a marriage. So if the choice of wife is there, if the two adults who are living together, they consented to such a living, then the relationship in which they are to which they are a party of, it cannot be discarded then and there. If it cannot be a relationship which is arising out of a valid marriage, then it will be a relationship in the nature of a marriage, which is provided for under the Domestic Violence Act. And now, with respect to the case of Priyanshi, the court noted that none of these judgments that dealt with the issue of life and liberty of two matured individuals in choosing a partner, or their right to freedom of choice as to with whom they would like to live. The judgments in the case of Nuja and Priyanshi, they are not laying down good laws, and therefore the court held that the FIR be quashed as the offences mentioned above, they were not established, and the right to freedom of choice while choosing a partner, it was therefore ascertained and upheld by the court. The parents of petition number 4, they sought visitation rights from the court, and the petition number 4, the court stated she has every right to decide and choose whom she wants to meet and who she does not want to meet. The court cannot interfere in this. However, the court stated that it is expected that the daughter to extend all courtesies and respect for her family, and the petition therefore was allowed. So that's all we have for this note. At the end of it, you may find a list of abbreviations which we have used in the note. You may refer to it. And thank you for being with us.